Lordship is upholding the judgment, my lord, I got benefited this respondent. Suppose overruling it, my lord, the interest should not, 100%.
That you can argue.
180% it is coming, my lord. Actually, more than a crore.
Yes, all right. Thank you.
Much of.
We are for Balrampur Chini. Just 2 minutes, Your Lordship. Just stepping back. Now it has become a center versus state issue, which is rightly so. But it started out as me or the private party versus the state issue, and the legislation in question was the UP Excise Act. In light of which, and why we say it, because in light of the 3 issues which are before the court, the first issue is regarding entry 84 list 1 and the counterpart entry, which is entry 51 list 2. The issue regarding that is alcohol fit for human consumption. The second issue is regarding entry 8 list 2, which is intoxicating liquor. And the third issue is regarding entry 33 of list 3, which is to be, as per the other side, read along with entry 24 of list 2, which is on the industries aspect. And the counterpart entry in entry 52 list 1.
What do you have to add?
The only thing add is, Your Lordship, in the UP Excise Act, we have to see the legislative conscious from the act itself. If Your Lordship will see the act, because no one has shown the act itself defines what a liquor is. The UP state says liquor is intoxicating liquor, and in what it includes, they add all the beverages. So the argument sought to be made now is contrary to the legislative conscience itself. If Your Lordship takes the statute for 1 minute.
Where do we get it? We just make a note and then.
Your Lordship, it's in volume 4, page number 682. There are 4 definitions which are important in this statute. The first is excise duty, which is at page 692. Because it says excise duty as per entry 51 list 2.
Excise duty 692.
Then definition of liquor, which is also at page 692 bottom, Your Lordship. I'll just read it out. It says liquor means intoxicating liquor and includes spirits of wine, spirit, tari, panchai, beer, and all liquids consisting and containing of alcohol. So there is no question of moving beyond these beverages or taking assistance of entry 8. The other is excisable articles, which is definition at page 696. Excisable article, they specifically mention, means any alcoholic liquor for human consumption.
Yes.
And then, Your Lordship, section 13, read with section 19 and 28 of the Act, says that any transport or removal of these excisable article, that is to say any alcoholic liquor fit for human consumption, will be charged with a duty. So they, in the legislative aspect, have only relied on entry 51, which as per every submission is barred by entry 82.
Thank you.
Entry 84. Much more.
Yes, Mr. Dwivedi.
I was to answer, my lord, that Tikaramji issue, my lord, if Your Lordship recollects, whether it is, my lord, my submission is this, my lord. Lord, Tikaramji essentially does 3 things. A, it compares the 2 acts which were in question in that petition and says that there is no repugnancy in that matter, with which, my lord, we are not concerned.
Yes.
But second, which in my submission is an obiter because that was not required to be decided, is the term industry in entry 52 list 1 is restricted only to manufacture, neither pre nor post manufacture. And third, Tikaramji does not even go into occupied field and says that once there is no notified order, the scope is open for the state to step in and legislate.
Does not go into occupied.
Does not go into it and says that, but that is clearly an obiter. It was not required to be decided. There is no discussion why one view over another view. So it is an obiter. But so far as second issue is concerned,
Yes.
regarding the restricted meaning given to the term industry, so there are some legislations in place as on date referable to entry 52 list 1. So they might be impacted. In future, the parliament may require, my lord, in peculiar circumstances, to control, my lord, right from raw material till the end product's usage. So, my lord, I am not, my lord, respectfully, my lord, concerned with whether Tikaramji is overruled, affirmed, or explained, my lord. That's entirely your lordship's prerogative. But, my lord, kindly bear these factors in mind. So far as second is concerned, whichever way, your lordships may, my lord, accept our submission that there was no legal or other necessity to restrict the meaning of the term industry. It is wide meaning. And if it is not so, then even entry 24 list 2 also will be impacted. Because then state also will have only manufacturing part. So I am not, my lord, against state. I am saying state also would be adversely affected.
Thank you.
So these are my submissions. Good night.
Yes, Mr. Dwivedi.
Wait, please. We have compiled the rejoinder submissions also for lordship's convenience. It's a short 10 pages only, 15 pages.
Where will you find it, Mr. Dwivedi?
Volume 1M
This.
on the screen.
PG code. Yes. Then you can scroll.
That's digital PC.
It's called.
Digital PC.
Yes, on.
Then you can scroll it actually. Yes.
Law, as I have been taught, and as I have learned over the years, and your lordships have hammered it in, and that is, we are a federal structure. But the power of the state under list 2 cannot be controlled or regulated by parliament. That's the concept of cooperative federalism. Federalism, your lordships have churned out, time and again. And if I would refer to your lordship's judgment, 2000.
Would you like to read that out? We have that para 1, para A. Let's see how you have formulated it.
I was responding to what was argued today.
Right at the end. Sorry.
So the question is not, what we are being told is that in 1951, IDR contained industry and industrial alcohol and other things. In 56, it was modified to include alcohol via under the heading fermentation. And then 16, again, it has been changed. Now I ask myself, is the jurisdiction of the state going to conform to the law laid down by the parliament? Or can parliament, by constantly modifying and amending its own act law, dictate what is contained in the state list? Your lordships have very clearly said state list reserved for the states, and states have plenary power, which power cannot be controlled by parliament or by parliamentary legislation. That's not is absolutely clear. But yet my friends say that entry 8 has to be guided by legislation of parliament, 1951 Act. Now I ask myself,
What is being argued, in fact, is that forget what the makers of Government of India Act 1935 had in mind when they incorporated NT 31, which is the same, verbatim the same as entry 8. What they had in mind when they incorporated entry 40, which is excise duty, same as entry 51, list 2. My friends further say, forget what the framers of the Constitution saw in the Government of India Act and these entries and incorporated that verbatim in the same manner as in the Government of India Act. My friends further forget the fact that the legislative history, if these Government of India Act and the Constitution entries are seen in the light of the legislative history contained both the things in the same manner as incorporated in the term intoxicating liquor in entry 31 of the Government of India Act. So what we really have to see is what did the makers of the Government of India Act have in mind when they incorporated entry 31, list 2. That is intoxicating liquor and in all its facets. And not anything else. No. The parliamentary law may say whatever it wants to, Parliament may include whatever it wants to, but we cannot on the ground of parliamentary supremacy justify this kind of encroachment on the state list. So therefore, what is absolutely essential is that before we go into the issue, whether intoxicating liquor means what I am claiming or what they are, or it means what they are claiming. No? Before that, we must be clear about the federal aspect that is embedded in our constitution. And the best judgment in that regard, not the latest one, I would submit Lordship's judgment for 2018, 8 SCC 501. That is at volume 5, PDF page 1299. The relevant paragraphs note I have given my note
Volume.
at page 1.
Volume 18, volume 8.
The emphasis is quite clear and unequivocal that state powers are plenary within their own list. They cannot be tempered by Parliament. Now, what are being
You are supposed to give your rejoinder today, right?
Ma'am.
But why this particular document is uploaded during the court hours? We are having to stress our hand
quite
and get away from the notes that we are taking with our hands. It should have been incorporated before we commence proceedings.
We can keep a mouse here.
To the technical issue
Yes.
and what we are having to concentrate on the
Right.
law is getting diverted.
quite. No,
I mean, at least I'm speaking for myself. I'm not speaking for other members of the bench.
I can understand that difficulty because since we are confining ourselves to this technology part, we can't. Obviously, there's no.
So if it was done at 10 o'clock, it would have been incorporated in our devices.
I think
Was it 9:45, my lords? Was it 9:45?
Why not at yesterday evening? Why not today at 6 o'clock? Don't try to give a justification 9:45. 9:45, we are getting dressed for court.
quite right.
9:45, what do you do, if I may ask you, young man?
Coming to the.
My apology, ma'am.
You are looking at your, preparation of the court, or you are getting dressed for the court? I think we have the same routine.
Extreme apologies.
No, it's just that I am a little disturbed, that's all,
Everybody.
It's inconvenient and difficult too, I can understand. Yes. Pull it. Yes. Or if I may enlighten the entire note, this was the evening whiskey which caused the problem. But my apologies, Lord, Lordships may. My extreme apologies, Lord.
It from you.
Yes, Mr. Dedi.
I'm just to
Right.
lighten the entire thing.
Yes, Mr. Dedi.
Now, Lord, therefore, what I was saying is, Lord, what we have to look into is, what does the Constitution provide, not what does the law provide of Parliament. Parliament would always be encroaching. The nature of power is encroaching, and they therefore always try to encroach. Now, that is why I was referring to 2018, volume 8, SCC 501, paragraphs 94 to 120, 123 to 133, 466 to 468. And then, Lord, that 9 judges judgment, Lord, of Jindal, in which Lord Chandrachud was there, Lord. 2017, volume 2, SCC 1, volume 12, paras 13 to 16. This is PDF page 670. 8. PDF page 678. PDF page 678.
Given the PDF.
Volume 5. Now, Lord, if I may, Lord, Lordship, since Lords have it here, can I place the A part of my?
Yes.
The words notwithstanding clause 2 and 3 and subject to in Article 246(3) are not unlimited. They are limited by the context, that is the basic structure of the dual polity. Admittedly, both the union and the state legislatures are plenary in relation to their fields. Both derive equal powers of legislation only from the Constitution. The states share sovereignty with the union, and that they are legislative plenipotentiates within their legislative fields. They are neither appendages nor satellites of the union, but are its co-equal. This is precisely what Lordships have said in 2018, following large number of decisions in the earlier. Therefore, keeping in the context in view, we have to analyze the scope of the aforesaid phrases. The issue of parliamentary supremacy arises only in the event of a conflict of entries. Can you note this one? It arises only in the event of a conflict of entries on the 3 lists, and not in the case of conflict of laws that attracts question of repugnancy or occupied field. Not only the entries in the union list, but all the legislative entries in the other lists are to be interpreted widely and liberally. While so interpreted, conflicts or overlaps may arise, which are resolved as per the principles evolved in Hext Pharmaceuticals. And I have, for Lordship's convenience, laid down certain paragraphs which are relevant. In fact, this judgment, Lord, Hext Pharmaceutical, which is kind of an authority for this purpose. It in fact says if there is a conflict between the entry in the list 1 and entry in the list 3 and 2, sorry. then the effort has to be to reconcile the conflict harmoniously. And every effort should be made to reconcile harmoniously. It is only when no reconciliation under any circumstance is possible, then only then this parliamentary supremacy kicks in. But then for that purpose, they went to this extent, Lord, that if the central list is a general list, that's what is considered in this thing. And if the state list overlaps the central list, then carve out a space for the state list and then create whatever normally could be given to the center and appropriate space for the state. It's not that we will wipe out the state entry because there is a conflict. So this kind of interpretation has been followed by our lordships all throughout, and I'll show it till about the 2002 ITC. The parliamentary supremacy as held in the above case is limited and not absolute. It operates only when there is a irreconcilable conflict of entries. The irreconcilable conflict will only emerge when all efforts at harmonious reconciliation fail. One of the foremost methods of reconciliation, as pointed out, is to cut down the union entry and carve out a reasonable space for the state entry. That's what Lord Hicks says.
Yes.
So we should not attribute, Lord, with all due respect, Lord, we should not attribute everything to the concept of parliamentary supremacy. We should be hesitant in going to that because lordships have said that any interpretation that whittles down the power of the state should be avoided. This Hex Pharma, Lord, I am informed, was reaffirmed in innovative, Lord, the arbitration matter. Now, bearing this in mind, Lord, let us analyze what is the scope of entry 8.
So if we have to then sort of go into the content of entry 8 as which says intoxicating liquor.
And
According to you, intoxicating liquor includes all liquids which are alcoholic. Now, and therefore it's not really something which is only for, which is portable or for human consumption. Can you just formulate why you are why
Yes,
that interpretation
exactly.
you're really
Yeah, I've given a cogent reason for that.
just
Two sentences we can, now that my letter should finish.
yes. So, Mr. Dwivedi, just tell us if you can summarize them in points.
Yes, yes.
Why intoxicating liquor, as you say, means all liquids containing alcohol. These are the words you have used in our written submission.
Quite right.
So let's just take it down step by step. Just give us the
This
reason.
was what was in the mind of the makers of the Government of India Act 1931.
All right. Just one second. This was how the makers of the 1935 construed the phrase. Now, when you say this was how the makers of the GOI Act 1935 construed the phrase,
My lord.
what is it? How do you support it?
Yes. Now, Lord, when we see the entry 31 in the Government of India Act 1935, then naturally we'll have to find out from where did they get this.
What is the entry? What is entry 31? Can you just again?
Intoxicating, verbatim the same as in
Verbatim the same.
verbatim as in entry 8. I mean, it includes certain other items which included opium in.
Right, right.
With which we are not concerned, so I was not wasting lots of time. And when it came to entry 41, another important thing is, which lends credence
What
to
did
my-
it include apart from opium?
Yes, until I got the Government of India Act.
Sanskriti, is that in somewhere on in our one of our compilations? Entry 28, oh, sorry,
As written submission.
so that we don't have to again hunt for them. Can you just tell us which volume?
Volume 4 is page 1.
Mr. Tushar Mehta, Sanskriti?
2G, 2D, 2D.
2D. Page 28.
No, in the, yes.
Yeah, we got
Government of India Act, I've got a Government of India Act.
Yeah, we also got it now.
Yes.
Entry 2D, volume 2D, page 28.
His Lordship will stop at intoxicating liquor from the word starting with opium, other narcotic drugs, but subject as respects opium to provision list 1 and respects poisons and dangerous drug provisions. So up to liquor is,
intoxicating liquor, that is to say.
the Lordship now compares right from opium to the end, all the other words are different.
And I would request Lordship to ignore that, that's
Yeah.
not relevant for our purpose.
Lordship wants the original text I've got.
Yeah, that is to say the production, manufacture, possession, transport, purchase and sale of intoxicating liquors.
Stop.
Right. So everything from opium up to the end is deleted and narcotics drugs is deleted. Yes. All right, we got it. Then
Number of the question is not what did they have in mind and where did they get this from? There is entry 41 also of the Government of India Act, which is important, Lord. Entry 41 is the taxing entry, not excise duty, which is verbatim in the same form as it was in the Government of India Act, entry 41. Entry 51, list 2 of the Constitution is verbatim the same, Lord, so far as the relevant part is concerned, verbatim the same as entry 40 under the Government of India Act.
entry 40, right?
Entry 40, Government of India Act 35. Now the question is, these two phrases were not new phrases. These two phrases were not which had not dawned all of a sudden under the Government of India Act. These two phrases are well understood and utilized in various local acts, excise acts. And that is where I'll kindly have my written submission, Lord, the original written submission, and I'll refer to 2-3 pages only. Because that's the key stone of my entire argument, Lord. Both entry 31 and entry 40 in the Government of India Act were verbatim borrowed from the local acts. Now, Lord, it is, if your Lordship would kindly come to my usual written submissions, Lord, volume 1, A, page 8.
Yes.
I had referred earlier also, but then since you Lordships want to know.
And according to them, according to you, therefore, that this had meaning, it was not a meaning which was
Exactly the
confined
same
to,
word.
it was not
Exactly.
confined only to potable liquor.
Yes, initially these local acts used liquor, which included all kinds of liquor, all liquids containing alcohol, including denatured. Then, Lord, comes the Madhya Pradesh Act, Lord, at page 10. The convenience, I had only quoted the definition clauses, Lord, of those acts. Lordship would have page 10. MP Excise Act, excisable article.
So according to you, the meaning in the local acts was,
Adopted.
all right. Then what is the next point, Mr.?
No, but kindly just have a
So
look
we've
at.
got your point that entry 31 and 40 were borrowed from the local acts, and therefore they must have the same meaning as in the local act, which
And
includes.
what I wish to point out here is, not permit my little insistence on that.
Yes.
For entry 50 and 40, list 2, sorry. The Government of India Act follows the definition of excisable article, which says alcoholic liquor for human consumption. Excisable obviously means tax. So it uses that phrase. But when it comes to liquor, which is section 2 of the Act, it means intoxicating liquor and includes spirit, wine, spirit, and all liquids consisting of or containing alcohol. Spirit is defined to mean all liquids containing alcohol. Now, what is interesting here is none of these acts, when it comes to regulatory power, dissect between the industrial alcohol, the denatured spirit or the rectified spirit and the potable alcohol. They don't. None of the acts. And these acts were of vintage 1915, 1908, 1910, 1912. The only dissection which these acts had was in respect of excise duty, where it was said alcoholic liquor for human consumption would go there. And of course, the Dominion wanted its share of the pound of flesh. Therefore, they said we'll have the industrial or the non-potable there, excise duty. The Constitution has verbatim borrowed and adopted the same system. Now, I ask myself, for excisable article for the purposes of levy of excise duty, the phrase used is alcoholic liquor for human consumption separately. There's a dissection. Rectified spirit and denatured spirit may not fall there, but for human consumption, therefore, potable. But if the idea was to have the same meaning here of liquor and intoxicating liquor, why would they not put the same word here? But instead of that, all the acts unanimously did not dissect for regulatory exercise of power, but the liquors. In fact, if your lordship would see section 213 of the liquor and all the acts, it says all liquids containing alcohol, which means alcoholic liquor. So alcoholic liquor was in the regulatory regime, while the alcoholic liquor for human consumption was for taxing regime. That was the dissection created by the local acts, followed by the Government of India Act. And why do I say please adopt this legal sense? Because the lordships have in Gannon-Dunkerley, the lordships were confronted with this similar issue exactly. Taxes on sale of goods. That was the word used in the Government of India Act. Lordships went into a history. How did this term taxes on sale of goods come? And then the lordship said that we must see the legal history of the term. How was it used in England as well as in India? And then they hit upon this Sale of Goods Act 1930, which was close proximity to the Government of India Act. And they said that definition must have prevailed because that was the legal sense prevailing at the time when the makers of Government of India Act applied their mind. No, it's not that everywhere we adopt this theory of popular sense or any other sense. Question is, Gannon-Dunkerley Constitution Bench clearly says, if there is a choice between popular sense or the legal sense, then we will adopt the legal sense born out of history, legislative history. This is 1959. But if a lordship would say, Garant Dankali is 1959, volume 1 SCR 379. It is volume 5B, sorry. In fact, they discarded the popular sense and said, no, it's sense in which it was understood by the makers. And what was that sense? Legislative history. Sale of goods. Now I ask myself, what is the difference between that case and this case? Note, why should that principle not be adopted here? The question to be, as I said, note, I repeat again, the question to be asked is not what the makers saw and thought, but the question to be asked is what the makers of the Government of India Act, that is British Parliament, saw. And what was the legal sense prevailing in which they saw the term?
Umar, you cited Justice Chagla's Balsara judgment. Can you just give us that cross-reference once again?
Volume 5F, Manoj, the Bombay High Court. 429, volume 5F.
That judgment is again based on strong and
Can you just go to that, Mr. Because that's the con. We have Balsara, which reverses Chief Justice Chagla's interpretation.
Balsara is the only case which deals with the legislative history, no other case.
Right.
Even synthetics doesn't deal with the legislative history, silent on that. Balsara is the only case which had adopted, in my opinion, the right approach as indicated in Garant Dankali, though it did not notice that judgment, but verbatim the same situation. So the choice before your lordship is to whether to rely on the legislative history and the legal sense which prevailed at that time, or to adopt some kind of a popular sense which may keep on fluctuating, and so will the entry. And that is the difficulty I sincerely wish to point out. My friend says in 51, IDR included power alcohol and industrial alcohol. Then in 56, they changed it to alcohol, which means including even potable alcohol. Then in 16, they again changed it. And then my friends say, please rely upon the Law Commission's report and the legislative debates of Parliament. How can they possibly not solve the riddle? I ask myself, not before your lordship. The issue is the interpretation of a constitutional entry. And entry 8 does not conflict with any central entry in the central list. So there's no issue of conflict. And if my submission is correct, that entry 8 includes, as I'm advocating, then perhaps where is the conflict, I ask myself? Where is the occasion to attract Article 246 of federal supremacy? Federal supremacy certainly cannot mean that we can snatch every entry from the state list. Because fact is not, if your lordship would recall 369, Article 369 clearly enabled Parliament to legislate on any state entry for a period of 5 years. Therefore, virtually every entry was within the sway of Parliament. But 369 was given a limited life of 5 years and expired. But should we still continue to adopt that? Look, there would be another confusion which I may indicate if lordships would not adopt my interpretation, but of this word intoxicating liquor. Intoxicating liquor contained all liquids consisting of alcohol. And therefore, under the Excise Act, they were being regulated, even medicinal and toilet preparations were being regulated therein as liquid containing alcohol. The non-potable liquor was also being regulated under the Excise Acts, local acts. Now, I ask myself, if we limit the definition of intoxicating liquor to potable alcohol, then there is no entry in any of the lists which provides that regulatory power will be exercised by any of the state or the center in respect of alcoholic liquor not for human consumption. Where will that go? I ask myself. Likewise, medicinal toilet preparations containing alcohol, where would they go? I ask myself. And the answer has been provided. The Indian mica and macanite Constitution Bench of 71 says rectified spirit and industrial alcohol, which is raw material to macanite industry, would be covered here, entry 8. And Lordship would recall, Lordship has seen Southern Pharmaceuticals, where medicinal toilet preparations containing alcohol were included in entry 8. But the whole situation is we have been following the legislative design created in the local acts, so far as alcohol is concerned. That has been followed all throughout the Government of India Act, and from there we have adopted it in the Constitution of India. Now we are saying segregate because the IDR says so. IDR wants, Parliament wants, maybe so. That's the desire of Parliament. Every power structure wants more power. As the saying goes, the popular saying goes, "Dil always mange more." But question here is, can we curtail the scope of that entry? That's the point which I was emphasizing on. And we cannot unless there is a very cogent reason to show otherwise. Mainly because industry is included in IDR. Now, some of the arguments were that industry, if intoxicating liquor, let's test it another way. Some of the arguments raised were that the intoxicating liquor being potable liquor will fall under entry 8, but the non-potable liquor will go toward industry in entry 24. Because if it doesn't go there, it can't go to entry 52. Now, Lord, I ask myself, Lord, if the framers looking into the background were adopting the scheme of Government of India Act and the local acts, why would they put alcohol not for human consumption in word industry in entry
Mr. Dwivedi, the Constitution uses the word intoxicating both in Article 47 and in entry 8.
I'll answer that. No, I have
Right?
one. I'll answer that.
So if it is used the same expression in both these, can that expression intoxicating have a different meaning in Article 47 and a different meaning in entry 8?
It will, and I'll show
And
why.
if it is to have the same meaning,
Yes.
then in entry 8 also it has to be intoxicating for the human being, isn't it?
I'll answer that. No, there's no difficulty in that. Intoxication word certainly implies the human factor. That it should be intoxicating to the humans. But does it mean that it should be as a beverage causing intoxication to the humans? Or can it mean also liquor which is capable of causing intoxication to the humans? The dictionary says intoxicating means both the things. That causes and is capable of causing intoxication.
But
to
what
humans.
is capable of causing is not something which is drunk normally. A beverage is a normal drink.
I'll tell Lordship.
That is an abuse of that.
But that may not be, with due respects, that I'll sold it.
Chief Justice Chagla, my learned brother, Justice Rishikesh Roy just pointed out, in the opening paragraph makes a distinction between the consumption of drink and foreign liquor and its application. And he then refers to also the fact that, it can be used, for eau de cologne. And he's also accustomed to the use of eau de cologne and lavender water. So he's made that distinction in the very first paragraph.
Important part is, and I went through that judgment more than once, no? Does it at all, I ask myself, refer to the legislative history, the Government of India Act? Because that was an act, remember, that was an act made under Government of India Act.
We may just benefit by reading the first sentence of Chagla's judgment.
Yes,
Yes.
Let us read that first sentence. It's a volume 5F 429 Omer.
Yes, sir.
one is to
429.
drink, the other is to use.
Right, right.
One is to drink.
Page 434. Here, we'll start. Here, we have.
The first paragraph lordships refer to. Yes.
Chagla, somewhere.
This is a petition by one Pram Nusirwanji Balsara, who is a citizen of India, has in his possession 1 bottle of whiskey, 1 bottle of brandy, both partly used, 1 bottle of wine, 2 bottles of beer, 1 bottle of medicated wine, 1 bottle of eau de cologne.
Good old Balsara would probably not realize, at that time, that he would be still living in the annals of our history.
Partly used.
Partly used.
It's really intoxicating.
No, then
Anyway.
the sentence should be finished.
Lavender water and some bottles of medicinal preparations. He alleges that he has been.
Before that,
No, before that,
medicated wine.
Immediately after that.
medicated wine, then rest of it, please read. 1 bottle of
Bottles of
medicated
beer,
wine.
1 bottle of medicated wine, 1 bottle of eau de cologne, 1 bottle of lavender water, and some bottles of medicinal preparations.
We have an entire picture of Mr. Balsara captured by Justice Chagla in that one sentence.
Now, my lord, finally notice that this is in the context of the Bombay Prohibition Act, not the Bombay Excise Act. I have placed before your lordship not the Bombay Excise Act, but the definition of liquor includes everything. But besides the point, Lord, since
the
your
next-
lordships were
Next sentence also,
very well.
what he drinks and what he uses.
That's important.
Yes.
Lord, that was a case confined to what was caught with him under the prohibition law. And therefore, what he was trying to explain was in terms of what was caught with him. Those were drinks, there's no difficulty. But the point is, does it necessarily mean that whatever he had will confine the jurisdiction of the state under Entry Act? But I am on an issue where the legislative entry of state, which your lordships had not said not is plenary for the state, would it be confined to these drinks only? As the legislative history shows, from local acts to Government of India Act and then the Constitution, it does not. The question here is not lordships were, perhaps it seems affected by the word intoxicating drinks coming in Article 47. Kindly notice last 2 lines very carefully. The state shall endeavor to bring about prohibition of consumption except for medicinal purpose. That means prohibition of consumption except for medicinal purposes of intoxicating drinks. In other words, medicinal purposes would always be there liquid. State can control. But it will not prohibit. Kindly notice the distinction. Not prohibition is for drinks which are consumed as it is, not beverage. So what 47 is advocating is that you prohibit the consumption because the idea was prohibition. But you will not prohibit medicinal purposes. State will not prohibit medicinal purposes, though it may regulate that. Of intoxicating drinks. Now, word is intoxicating drinks, which normally one can associate with the consumption as it is, the beverage. But if the idea of entry 8 was the same, then why not use the word intoxicating drinks there, I ask myself. Why have different words for the same thing? At every place, note, entry 8, then perhaps note 47, then perhaps note in entry 51, list 2. Why do they not, again, there's another answer to it, not why the framers use the phrase alcoholic liquor for human consumption in entry 51, list 2? If it meant beverage, as in entry 8, then the same thing could have been used here. I ask myself why. Not the question, not the immediately crops up. Not why use two entirely different phrases to denote the same thing. It was very convenient. They could have used, if intoxicating liquor meant always the liquor which can be had as it is and consumed, then the same could have been used in entry 51, list 2. 51 list 2 doesn't use that term. But instead it uses the term that was there in the Excise Acts. It follows that. When the Excise Act distinguished and dissected between the liquor that is potable goes to the excise duty and non-potable goes to the regulatory. But I'm not, again, I would be kind of repeating myself. Intoxicating liquor borrowed from the Excise Acts. Alcoholic liquor for human consumption for entry 51 list 2 borrowed from the Excise Acts. Why should we confine the meaning of intoxicating liquor? It has been borrowed from the Excise Acts. Not word intoxicating has to be understood widely. Your lordships have always said interpretation of an entry is always wide. So let us interpret it widely. Would it not include both liquor, which when had as it is as a drink causing intoxication, or liquor capable of causing intoxication to the humans? For instance, rectified spirit, blood, as I explained earlier, rectified spirit is nothing but alcohol which is diluted by pouring water into it and then drinking. As I had given an example, blood, even normal whiskeys, normal people have it with soda or water. But then it doesn't cease to be intoxicating when it is in bottle.
So what is the proposition? What is the proposition that you formulate?
The proposition is this, note, that the word intoxicating liquor has to be interpreted in the light of the legislative history.
Yes.
That is the legal sense. And therefore will include all alcoholic liquors containing alcohol. This is because Gannon Dunkerley says so, Lord. I submit with respect. Look, this judgment of Gannon Dunkerley, which I wanted to place on the earlier occasion, I'm sorry. Is Gannon Duncally's case. Kindly have that judgment, but I will not place it for lots. I have at page 4 of my rejoinder written submissions, I have referred to it. 1959, volume 1, SCR 379. It's in volume 5, 5B, B for Bombay. I'm sorry, but the term comes, Bombay comes really.
B page
Page 486, PDF page.
at
But the judgment pages are not 59 1 SCR 379, pages are not 390, 391. (390, 391), 397 to 416. And it's a classic case where they considered whether they should accept the popular opinion or the legal sense. And they said, no, we should adopt the legal sense. And that is why Lord Gannon Duncally adopted that legal sense. I referred to a large number of decisions. Because that gives an element of certainty. Otherwise, it will keep on vacillating. Secondly, the another important aspect of this argument is entry 51 list 2 is a taxing entry. Now, Lordships have settled it more than once, note that taxing entries are separate, the general regulatory entries are separate. And they do not cast any kind of shadow on each other. Now, here is a case where we are being told to interpret the regulatory entry in the light of the taxing entry. Should that be done is the question. If Lordship would permit me to place this, I have elaborated this, these 5-6 points which are essential. And that will conclude the matter earlier.
yes, let's quickly go.
Yes. Page 3, it begins, no? This is PDF page 4, perhaps. It begins.
Yes,
The scope and expanse of the word intoxicating liquor, in short, IL, have already been explained in my written submission at pages 2 to 20 under the heading A1 to A7. There is a need to analyze this phrase in light of the legislative history as explained above. Have not got it. Yes. The question to be asked is not how the framers understood it, that is its legal sense, but as to how makers of the Government of India Act 35 saw it. When they coined this phrase, IL, the legislative history, as in US or UK and the local excise laws and all, had already determined the meaning of intoxicating liquor as including all liquids containing alcohol, including denatured spirit, medicinal toilet preparations containing alcohol, etc. With this background, the makers of the Government of India Act utilized the phrase intoxicating liquor in entry 31. They further use the phrase alcoholic liquors for human consumption. Not the word is not fit for, but for. In entry 40 list 2, it is therefore reasonable to assume that they utilized both intoxicating liquor and alcoholic liquors for human consumption in the same sense in which they had depicted in the local laws as shown in pages 8 to 12 of the written submission. If the intent was otherwise, then the framers and the makers of 35 Act would have simply used the same phraseology in entry 8 list 2 as in entry 40 list 2 of the Government of India Act 35 or entry 51 list 2 of the Constitution. The two entries use different words and therefore have to be separately seen as in the light of the legislative history. The sense that emerges from legislative history is the primary sense as can be gathered from the following cases I have referred to. There is no parallel legislative history in any of the lists that may confer regulatory or controlling power in relation to alcoholic liquors not for human consumption, medicinal toilet preparations containing alcohol. The absence of any general regulatory power as above in any of the lists further corroborates that they were assumed to be under intoxicating liquor in entry 8 list 2. This again as per the local acts. That the local laws clearly defined and equated intoxicating liquor with all spirits, all liquids containing alcohol, including denatured spirit. The denatured spirit was a spirit being included in intoxicating liquor. This also is a way to, in a way, explains why word alcoholic liquor for human consumption not used in entry 8 list 2. There is no liquor that does not cause intoxication. Even denatured spirit causes intoxication. It has been denatured to prevent people from consuming it. Lord, what happens is when the denaturant is put, as per the local excise laws, a denaturant is put that makes it nauseous. Therefore, you don't have it. But it's not that the alcohol content goes. Alcohol content is there. There is a renaturation process. You can renature and then have. Therefore, to cut down regulatory entry 8 with the aid of taxing entry 51 list 2 by equating the two would not be very constitutional. Entry 8 is an entry that uses general words and therefore has to be interpreted widely. It is not made subject to any entry, unlike entry 24, 26, 27. Therefore, to make it subject to entry 52 would be impermissible. The dictionary meaning of the word intoxicating includes both the liquor that causes intoxication and the liquor that is capable of causing intoxication. I have annexed one of the meaning. It is further not permissible to determine the scope of entry 8 list 2 in the light of parliamentary laws enacted post-constitution and entry 52 list 1. This is amply settled by the above constitution benches. Otherwise, there would be grave risk of making the state appendages of the union, destroying the delicately balanced federal structure. The above shows why intoxicating liquor in entry 8 is wider and different from the phrase used in entry 51 list 2. It cannot be cut down by entry 51, taxing entry. Following points need to be analyzed, and this is a reiteration of the same, which I have indicated above. Accepting, Lord, if Lordship would have it from page 7 top note. The Constitution does not use industrial alcohol. This phrase is not a constitutional phrase. It's not there anywhere in the Constitution, any of the entries. And there is no general entry under any list stating industrial alcohol. If intoxicating liquor is potable liquor, it is clearly shown, while IA is nowhere shown, industrial alcohol is nowhere shown. To be traced, and therefore nowhere shown, to be traced by the courts through complicated logic. There is no entry for medicinal toilet preparations containing alcohol, etc. The reason is these were all included in intoxicating liquor, always as legislative history shows. Now, there are two cases not which deal with the industrial alcohol. Incorporating it in entry 8. Indian mica and macanite, paras are given. Then in 1980, volume 2 SCC 441, paragraph 12, 15, 16, 17. No, this is not. This is, yeah, this is first synthetics, the earlier. Then I have also already referred to Lord, that Southern Pharmaceuticals, which includes medicinal toilet preparations containing alcohol in entry 8. Expressly includes. That is 1981, volume 4 SCC 391. 1981, volume 4 SCC 391. This is PDF page 1985. We have, then up to page 8, Lord, I have given the reasons why intoxicating liquor would include all liquids containing alcohol. Then comes the next point, Lord, the scope of entry 52, list 1. Lord, it is quite uncanny kind of a thing, Lord, that this question of word industry in entry 52 is wide and expansive and includes both raw material and the end product. So, of course, I've referred to the judgments which have rejected this contention. But my friend relied upon the debates which he had annexed with the written submission. But before that, note, there is one judgment which is so well directed as well as well considered, I mean, where this point is well considered, is 1996 Allahabad, full bench. 1996 Allahabad, 135. It's a full bench, AIR 1996 Allahabad, 135. It's a full bench judgment. This is volume 5, PDF page, volume 5, PDF page, 2274. And kindly permit me to place this judgment, Lord, and I'll place what my friend had placed in support of his debate. In fact, that supports my cause rather than their case. In fact, the debates prove that the Tikaramji was correct. Volume 5, PDF page 2274. And the relevant paragraphs I may give to you, Lordships. Paragraph 7 to 9, 12 to 21, 12 to 22, in fact, no, I'm sorry. 32 to 39, 47 to 51, 53 to 64. All these arguments were raised in the debate before the drafting committee, and the drafting committee rejected the claim that the end product regulation, which is incorporated in 18G and then entry 33, should be put in entry the 52 list 1. That was expressly argued, pressed, and the drafting committee rejected this submission and said, no, we'll put it in list 3, entry 33. The reason was, they said that we need states' cooperation in these matters. Cooperation where they know the local condition and they will accordingly devise their ways and means. That is what the Lordships refer to cooperative federalism. Entry 33 is about that only. It refers to all that my friend had annexed. Would your Lordship want me to place it for Lordship? It's an interesting reading, but that's why I was.
So it shows just the relevant part, one para, which is.
No, the relevant part is not in one paragraph. That's the difficulty. It's in various paragraphs, one after the other. But the relevant part regarding the debate.
You can just formulate, the question is
yeah.
formulated at para 1. You may read that and then you may read the conclusion.
Very good.
Justice Khare judgment. Whether by virtue of section 18G.
Whether by virtue of section 18G of the Industrial Development Regulation Act 51, the state legislature stood denuded of power to legislate regulating supply, distribution, and price of molasses, a product of sugar industry, and was consequently incompetent to enact section 7. This is a case where the molasses, which is byproduct of the sugar industry and therefore raw material for liquor industry. So this was an industrial byproduct, which is product of the, the sugar industry, manufacture, which is a controlled industry. Therefore, where will it go? That was the question. Entry 33, list 3. And then in at least 5, 6, or maybe more, they have come to this conclusion that the framers had clearly rejected this ground that the entry 52 should be wide and it should include the end product regulation as well as other things, raw material. And they confined it clearly to production, leaving it to entry 33 is where states could also exercise power. Cooperative. And this is where they examine from page para 16. Paragraph 16. Again, the same logic, not the legislative history, has to be looked into. It starts actually from paragraph 14, where the judges have not utilized Shiva Rao and his narration of the debates and so on and so forth. Then it goes to 16, where they clearly hold that the debate, the drafting committee rejected the claim of putting it in entry 52 list 1. And then their lordships go into the issue of how to examine the entries in the light of the federal structure features. And then they deal with, surprisingly, every time this question was raised by the eminent counsel, Shri Shanti Bhushan, every time. Because he was generally, he was the leading lawyer for the sugar industry. So therefore, this question rose frequently. And he raised it up till 2002, Lordship. The same argument. The uncanny part is not that the same argument is raised time and again, relying upon the IDR Act for curtailing the expanse of states' power under entry 33. And the same argument is rejected time and again. And I have narrated not those 8-10 decisions where this argument has been rejected, at times with a reprimand. So this judgment, if read carefully, categorically rejects and dismisses their contention that industry word in entry 52 list 1 is very wide to include the end product as well as the. Now this judgment has been affirmed in 1998. 1998, 7 SCC, page 26. In fact, lordships need not take the trouble of writing it, but I have indicated in paragraph page 12 all those cases where this has been approved. Page 12, kindly have. And can you see the times in which, the number of times it has been rejected, and at times with a reprimand to the council for raising this. It starts from 56 SCR, that's the first case, goes on till 2002. Not the other ones, but 2002, volume 9 SCC. This is ITC. And interestingly, Sri Shanti Bhushan has been raising this argument from 1980, that is Ishwari Khaitan, 1980, volume 4 SCC. Every time it was rejected. Now again, the same argument is being raised on the basis of very same debate which has been repeatedly rejected.
What else, Mr. Dwivedi now?
I'm sorry?
What else remains?
Yes. Now, Lord, the question is, Lord, this is, Lord, this is not only approved in, Lord, Sriram Industrial Syndicate, but this is approved in Bailson, the Constitution Bench. This is again approved in ITC, this judgment, full bench. Lord, in ITC, which is 2002, I have narrated in page 12, and I have shown that. Again, the paragraphs. Then kindly come to page 10 of my this thing submission plus. Page 9, I have narrated those cases which have upheld.
Yes.
Then note page 10. The important aspect is not which one of the things which my friends are raising, not this document, this argument of a composite kind of a law made, which is code unto itself. And therefore, even if you don't legislate anything under the law,
Forbearance.
it is vacant because there is regulation by abstinence, that's what it says. Now, there are two things which I wanted to point out. Kindly have section 18G.
We'll come back after lunch.
Apologies to Justice Roy in the first place, Lord. I have given a submission 1-0, but I gave it this morning because all the submissions came on Tuesday afternoon. I was in Calcutta yesterday, but I hand wrote everything, not it typed. So I won't refer to it, Lord, since it was after 10 o'clock, but I will just.
It can be incorporated at lunch now. You can just give it to the
It's
court.
already given in the morning, but since your Lordship said not.
Uploaded on the drive now.
Lord, in fact, Lordship may make it as a part that all submission must come 24 hours in advance. So then all of us will. But this, what happened was all the submissions.
My
came in-
apologies, not for the inconvenience to your lordship.
No, not to you, but I think Samar Vijay, right?
Yeah.
Samar Vijay, actually, I should not have spoken in that fashion. So firstly, my, regret that these kind of words came out, but let me just put this thing. You see, when it is all paper court, whenever arguments are, we are making notes with our pen, ink, pencil, whatever, right? Now, this 9:45 thing has deprived me of this. That is the thing, right? So don't take it this thing, but it's just a matter of convenience only. That's what we say.
Lord, in 1-0, I was just attempted to answer this 6 questions referred by Lalta Prasad. Ironically, entry 8 was never referred to, but we have argued most on entry 8.
That's right. Mr. Dwivedi, another 15 minutes so that then we can hear Mr. Datar for about.
I'll take, I'm not going to rapid fire, just 25-30 minutes. Just 3 points I'm going to
Not
go.
since
But what I intend, subject to your lordship's approval, you have noted their submissions. I can't argue. There can't be a surrender. Their new fresh argument on one side and our response on the right side will file by tomorrow or day after.
Now, then they'll go on, then we'll keep it to that now. So,
There are some new
they will
arguments.
also respond to that. They will also then respond. It will be like impossible.
I leave it to you.
This is already what we have said.
So, Mr. Dwivedi, till 2:15, then 2:15 to 2:45, Mr.
Try my best to take it.
I'll take 10 minutes.
So we'll wrap up by.
Would my lord be sitting in alternate bench?
This will never end. Right. We'll see after Mr. Dwivedi ends. First, let Mr. Datta start at 2:15. 2:43 then we'll see how much time we have.
1-0.